Thank you, and I look forward to your questions.
Well, for your testimony, I'm going to start with Professor Klein. Critics of Section 702 contend that the query of 702 information that has already been lawfully collected should be treated as a separate Fourth Amendment event. Please explain what it means to quote-unquote query 702 information and whether or not that's legally sound interpretation.
Thank you for the question, Senator. I want to say at the outset that we all very much respect the Constitution. I'm a law professor. The Constitution is number one. We care about Fourth Amendment rights, and I would not support anything that I thought violated the Constitution. The issue here is that this is a database created, owned, and maintained by the government from information that has already been lawfully collected. Just like a filing cabinet in an FBI field office, we don't require a warrant for an FBI agent to go look at information the FBI already has in its files and flip through to try to solve a case. That's a prudent investigative step, and in fact, it's less invasive than going out to get a new warrant to conduct new surveillance on a person and collect data the government doesn't already have. The argument, and this is what the reasoning the district court relied on in the Hasba Drami case, is that if the government seizes, for example, a hard drive or a phone or a package under another search warrant or other lawful process and then breaks into that additional sealed container, that's a separate Fourth Amendment event. That makes sense in those contexts because those things are effects under the Fourth Amendment, effects with an E, a piece of personal property that is seized that the government is breaking into for investigative purposes. That's a separate investigative step. A government database is not an effect belonging to any of the people whose information may be recorded in that database. The government structures the database, the government architects the database, the government makes the entries and controls the entries in the database. Only the government can delete and access the database. It is not comparable to a personal effect that the government is then conducting a subsequent search on.
Professor Klein, I've raised concerns with the Department of Justice improperly limiting access to FISA court proceedings for nearly a year, despite a clear mandate from the last reauthorization to allow certain members and staff to attend, quote unquote, any proceeding. Can you please tell us why congressional oversight of these proceedings is important and whether or not you believe the Department of Justice procedures limiting congressional access comply with the law's intent?
Thank you, Senator. Yes, Congress constitutes tribunals inferior to the Supreme Court. Congress is the Article I branch. Congress created the FISA court, controls its processes, and could get rid of it if it chose to do so. It is very important that Congress be able to form its own impression, a detailed, thorough impression of how well the court is working. Members of Congress have the right to access classified information. Many of your staff members are cleared as well. So in my view, there should be a fairly seamless procedure for members of Congress and their staff to go and see FISA court proceedings and form their own judgments.
Mr. Baker, for much of your career, you've evaluated the failures that led to 9/11, and ongoing debate centers around, quote unquote, the word wall between law enforcement and intelligence agencies. Many argue this wall was a big part of why the government missed 9/11 attacks before it was too late. Please talk about the necessity of information sharing between the intelligence community and law enforcement and the dangers of having a wall between.
Yes, and I've talked about that in the opening remarks as well. It's just a tragedy that in an effort to answer objections from law professors and civil liberties groups that there might be some kind of backdoor access, this wall was created to reassure them. It didn't reassure them. They kept asking for more. And that the government was afraid because of the politics to fight when the FISA court said, we're going to make that part of our FISA orders. And then we're going to punish FBI agents who deviate from our interpretation of the wall. The Justice Department was afraid even to appeal that order because of the political implications of that until after 9/11. The result of that was that the information that should have gone to the Cole Bombing Task Force never got to them, They never used their enormous capabilities to find these people. There are tragic emails between people arguing about whether they could bring in the FBI in which they say, someone's going to die. Why are we protecting Al-Qaeda this way? Never happened. The civil liberties concerns won out, and the fear of losing their careers prevented the FBI agents from having those discussions with somebody who actually could find the attackers before they attacked.
Senator Durbin.
Thank you.